All right, well, good afternoon, everyone, and welcome to this webinar training titled Sentencing Guidelines in MAGS 101 for State's Attorneys, Parole and Probation Investigators, and Defense Attorneys. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, which we commonly refer to as the MSCCSP for short. The sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. And accordingly, your participation in this training and staying up to date on the sentencing guidelines is important because it helps to promote the consistent application of the guidelines. I do want to note that today's webinar, it is being recorded, and this video or a similar webinar video will be made available on our website. So if you ever need a refresher, or if you have colleagues who weren't able to attend and are interested in viewing a recording of this webinar, please direct them to our website. So before we get started, I just want to go over some general webinar housekeeping. I know we're all very familiar with Zoom, so I do just want to note that we are asking participants to remain muted throughout the course of the presentation, just to ensure that we get through it in a timely manner. We have a lot to cover today. That said, we certainly encourage any and all questions that you have. So if you can just submit any questions through our chat box here. Two of my colleagues, our research director, Stacy Nacheka, and our program analyst, Sarah Bowles, are attending this webinar and will be happy to answer any questions that you have. Coming through the chat box, you should be seeing a PDF of today's presentation in the next few minutes, so you can feel free to download that or print it out for future use. So let's move forward to the agenda for today's training. Many of you are probably somewhat familiar with the guidelines at this point, but I know that we do have some newer practitioners who are joining today. So I thought it would be helpful to start by providing some background information about the purpose and goals of the Sentencing Commission. Then we're going to get into the various sections of the guidelines worksheet. We'll talk about how they should be calculated. And then we'll also look at some special applications that adjust the calculation of the guidelines in certain scenarios. And then we're going to wrap up with a brief demonstration in the Maryland Automated Guideline System, which we commonly refer to as MAGS. And throughout the presentation, we're going to look at some recent updates to the guidelines. Okay, so let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. Maryland was actually one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary. In April 1979, the Sentencing Guidelines Advisory Board, which was formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. The guidelines in Maryland were in effect statewide for about 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. Now, the enabling legislation that creates the current day Sentencing Commission outlines a statement of intent for the MSCCSP in Criminal Procedure Article Section 6-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that sentencing policies should reduce unwarranted disparity, including any racial disparity, and sentences for criminals who have committed similar crimes and have similar criminal histories. Second, that sentencing policies should help citizens to understand how long a criminal will be confined. And third, that sentencing policies should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And then finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the commission has a few primary responsibilities to help address these goals, with our first major responsibility being that we implement and maintain the state's voluntary sentencing guidelines. This is accomplished through the second major responsibility, which includes the collection and maintenance of an extensive database, which is assembled via all the data submitted on sentencing guidelines worksheets. Finally, the Commission is responsible for providing training to criminal justice practitioners to promote the consistent application of the guidelines and the accurate completion of the guidelines worksheet. Now, the MSCCSP was created as a balance board of 19 members from all three branches of government. The Commission is currently chaired by Judge Brian L. DiLeonardo from the Circuit Court for Carroll County. Membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate's court representative who serves as the Chief Judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. Appointed members serve terms of 4 years and are eligible for reappointment. The MSCCSP makes decisions with respect to the guidelines after deliberating with the many stakeholders that encompass the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the Commission. Now let's get down to the basics here. What is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories, they're treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The sentencing guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and his or her crime that are most relevant to the sentencing decision. And they help provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. Let's discuss some of the basic principles of the sentencing guidelines here in Maryland. First is that the sentencing guidelines in Maryland are voluntary, so judges may, at their discretion, depart from the guidelines. The voluntary nature of the guidelines emphasizes that they are designed to be a tool to help inform sentencing decisions, and they are intended to complement rather than replace the judicial decision-making process. The guidelines are also intended to be primarily descriptive. So in other words, the guidelines are informed by analysis of actual sentencing practices and are designed to illustrate to judges how their colleagues are sentencing on average for a typical case. The descriptive nature of the guidelines means that they are not intended to be static, but rather they are dynamic, and the guidelines may be amended when the data indicate that the sentences are not consistent with the recommended ranges. And the final basic principle is that the Maryland guidelines are generally limited to cases that originate in the circuit court. Now, before we take a look at the scope of the guidelines in greater detail here, we're going to start with a poll question. I have a couple of these scattered throughout the course of the presentation. Common questions that we receive, so I thought they'd be helpful to highlight during this presentation. So beginning with a true or false question here. Maryland sentencing guidelines are limited to felonies prosecuted in a circuit court. I'm going to go ahead and launch this poll question. Just to note, your answer is anonymous. Again, this is just an exercise to help highlight some frequently asked questions that we receive. So true or false, Maryland sentencing guidelines are limited to felonies prosecuted in a circuit court. I'll give you all just a couple of seconds to make your selection, and then we'll take a look at the answer. All right, looks like majority have selected here. So let's go ahead and share the results. Okay, so 22% think this is true and 78% think this is false. So let's go ahead and take a look at the answer here. Now, the answer is false. The guidelines are not limited to felonies prosecuted in a circuit court. They can also include misdemeanors that are prosecuted in a circuit court, as long as the convicted offense or offenses does carry the possibility of incarceration. So let's take a look at the scope of the sentencing guidelines in greater detail here. So as I just noted, the guidelines apply to criminal cases that are prosecuted in a circuit court. The sentencing matters that you see on the left-hand side here require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court, They are only guidelines eligible if a pre-sentence investigation is ordered. And then circuit court original sentencing is adjudicated via a probation or judgment are also guidelines eligible. Now, in addition to original sentences, the guidelines are also collected for reconsiderations or modifications, as well as 3-judge panel reviews if the sentencing event involves a crime of violence as defined under Criminal Law Article 14-101, and there is an adjustment made to the original active sentence as a result of that reconsideration or modification. So these guidelines eligible reconsiderations and modifications, they can include sentence adjustments imposed pursuant to Maryland Rule 4-345, a Health General 8-507 order, or again, a 3-judge panel review. Now, on the right-hand side here, these are scenarios that are handled by judges in a circuit court, but they are excluded from guidelines coverage. So they include jury trial prayers and appeals where no PSI was ordered, if the offense does not carry the possibility of incarceration, violations of local laws or municipal ordinances, probation violation hearings, criminal non-support and criminal contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply to district court sentences. Now, I do want to note that we have worked with GIS to establish a guidelines eligible case indicator. So here's a screenshot of an MDEC docket from the Circuit Court for Anne Arundel County back in June here. Now you can see all of the guidelines eligible cases listed on this criminal docket. They're flagged with this MAGS yes indicator, indicating that it is a guidelines eligible case. So I did just want to point out this guidelines eligible case indicator. If you think it would be helpful for you to look to these criminal dockets, just so you know which upcoming cases are guidelines eligible, and therefore you would need to initiate a guidelines worksheet for. We definitely recommend looking to these dockets. We worked hard with GIS to really fine tune the criteria, so it is very accurate. That said, it's possible that a case gets flagged as eligible when it may in fact not be. So just keep in mind all that prior criteria that we were discussing on the last slide here. But again, it is very accurate. And I know from feedback we've received that a lot of practitioners do find these dockets helpful. So next, let's discuss how the guidelines data are utilized after sentencing to inform policy decisions. So generally speaking, the data are assessed to review sentences and help to inform the commission whether changes to individual cell ranges or offense seriousness categories are warranted. So for many of you, you may have been utilizing the guidelines last year when we actually made changes to the property and drug matrices. A lot of those individual cell ranges were lowered to more accurately reflect how judges were sentencing in those particular cases. And that came from an analysis of data spanning the course of several years. So all that to say, it's very important that we're getting as much data as possible to help inform these sentencing policy decisions that we do ultimately make. We also use the data to monitor compliance and to see how often judges depart from the guidelines for specific offenses and offense types. And then finally, the data are also used to inform the legislature of sentencing patterns for specific offenses or offense categories. Every year, we publish an annual report detailing various sentencing trends throughout the state of Maryland. If that's something that may be of interest to you, you can feel free to check out all of our annual reports on our website. So next, I want to discuss a little bit, provide some background about the guidelines worksheet itself. Now, it serves two primary purposes. The first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data, so the commission can make informed decisions about sentencing policy. Criminal Procedure Article 6-210 requires that the commission collect sentencing guidelines worksheets, automate the information, and monitor sentencing practice. So now that we've discussed a little bit about the background and the goals of the Sentencing Commission, we're going to move on and start talking about how to calculate the sentencing guidelines. And I'm going to begin by defining a single versus multiple criminal events for guidelines calculation purposes. Now, a single criminal event is defined as one or more crimes committed in the course of the same transaction. Now, additionally, this language that you see noted in red, this became effective earlier this year on February 1 and states that in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes were 1, committed close in time in an uninterrupted course of conduct, 2, occur within the same location, and 3, are similar in nature or intertwined, for example, whether they share a common scheme or purpose. Now, this language, it drew on guidance that was provided by a 2022 Supreme Court opinion. And while it doesn't alter the guidelines rules in any way, we do think that these revisions did help to provide further guidance to practitioners when determining whether multiple crimes were committed during the course of the same transaction. Now, multiple criminal events are defined as more than one criminal transaction committed over a period of time. Multiple criminal events being sentenced together, they may have occurred on the same date or different dates, but generally offenses that occur on different dates are almost always considered separate criminal events. They often also have their own unique case number. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events that are sentenced by the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for each sentencing event. We're going to look at what that looks like on the next slide here. Before we do, I do want to note that merged or null prost offenses should not be included on the guidelines worksheet. So if they're initially added, but it's later determined that certain offenses were null prost or merged, they need to be removed from the guidelines worksheet prior to submission. Okay, so let's look at an example to illustrate how one sentencing event may include multiple criminal events. And I know the text is really small here, so bear with me. On the upper left-hand corner here, we have a distribution of PCP that occurred on July 10th of 2021, has its own unique case number ending in 4001, and it has its own individual guidelines range calculated here. Now, in the lower right-hand corner, we have an assault first degree that occurred a couple of months later on January 25th of 2022, has its own unique case number ending in 8001. Now, by guidelines rule, each separate criminal event should correspond to their own guidelines worksheet. So even though there's one convicted offense per criminal event in this scenario, it's still correct for both criminal events to be populating on their own separate worksheet. As I mentioned, there's individual guidelines ranges calculated for those offenses. However, there is still one overall guidelines range calculated between them, given that they are a part of the same sentencing event. So this is how the guidelines worksheet should look when you're initiating worksheets for multiple criminal events that are a part of the same sentencing event. And when we get to the MAGS demonstration, we'll go over this all again. In the test case I'm going to be showing you, it is a multiple criminal event, single sentencing event scenario. So next, we're going to be discussing different sections of the guidelines worksheet and how they should be calculated and completed. So the section that you see highlighted here, pretty self-explanatory. This is the convicted offense information. So it's where we capture the date of the offense. And then just starting in the upper left-hand corner here, this is noting at this sentencing, the number of convicted offenses and criminal events. Now, I do want to note, MAGS will calculate these numbers based on how you enter that information into the system. But if you are initiating guidelines for a sentencing event that involves multiple criminal events, you want to make sure that ultimately these numbers are accurate, because the number of criminal events does factor into the overall guidelines range calculation. So just important that you're paying attention to how these numbers are calculated. Jumping down to convicted offense title, based on the offense that you select in MAGS, it'll automatically populate the CJIS code, the statute, the statutory maximum, if there were a mandatory minimum. And then based on the case number that you enter for that convicted offense here, that will be populated on the worksheet. Now, I do want to talk a little bit about this column here. It has the Roman numeral equivalents of 1 through 7 as the header. That's the seriousness category column. And I'm going to divert from the worksheet for a second to talk a little bit more about that in greater detail here. Now, again, many of you are probably familiar with the general framework of the guidelines, but I do just want to give a brief overview of the basic premise of how guidelines are calculated. Maryland has 3 separate sentencing matrices. We have one for property that you see here, one for person offenses, those typically involving victims such as assault, robbery, as well as weapon-related offenses, and then another matrix for drug offenses. Now, the guidelines were designed to take both offender and offense characteristics into account. So we can see here, looking to the left-hand side, this is the offense seriousness category column. Each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And we can see for property offenses, those range from a 7 all the way to a 2. Now, this top row here, this is the offender score. We're going to talk about that in greater detail later on, but it captures components of an offender's prior criminal history. So walking through an example here, if we have an offender who has no prior criminal history, so let's say they have an offender score of 0, and they were convicted of a theft less than 100, which is a seriousness category 7 property offense, the recommended range would be probation to probation, looking to the matrix here. So again, just a basic example to show how the guidelines are calculated, and also to reiterate how critical of a role the offense seriousness category plays in terms of guidelines calculations. All right, so jumping back to the worksheet here, the next section we're going to discuss is the offense score section. So the offense score only applies to person offenses. I just mentioned those typically involving victims as well as weapon-related offenses. Now, the offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components, that being the seriousness category, victim injury, weapon presence, and special victim vulnerability. Now, the first section being the offense seriousness score, it provides a conversion chart shown on the worksheet whereby the least serious offenses, those being the categories 5 through 7, are assigned 1 point, all the way to the most serious, those being the category 1s, are assigned 10 points. Now, with regards to the offense score and the seriousness category of an offense, it's important to note that generally any attempt, conspiracy, or solicitation to commit a given offense is assigned the same seriousness category as the underlying offense. With that being said, there are a few exceptions involving some of the more serious offenses. For example, first-degree murder is a seriousness category 1 offense, whereas attempted first-degree murder is a seriousness category 2. The same is true for rape. So again, some of the more serious offenses. So if you are calculating guidelines for some of the more serious offenses, when you're selecting that entry in MAGS, you'll actually see the attempts, conspiracies, and solicitations to commit those given offenses listed as separate offense entries. We'll talk a little bit more about that once we get to the MAGS demonstration. So moving on to victim injury. So this is defined in our manual as reasonable proof of injury, which may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the convicted offense. So non-permanent injuries are assigned 1 point, permanent injuries or death are assigned 2 points here. We further note that psychological injury shall be based on confirmed medical diagnosis or psychological counseling or treatment, and that it is presumed not permanent unless otherwise demonstrated. And physical injury shall be more than minimal. Now, I will say with regards to scoring victim injury points, there does tend to be some gray area. So for example, we've gotten questions if there was a victim of a stabbing and the victim sustained a scar as a result of that stabbing. Would that constitute a non-permanent injury or a permanent injury? And the answer is that the instructions in our manual don't get into that level of detail. So in a scenario like that, where the instructions in our manual do not explicitly address how points should be scored, it is at the worksheet preparer's discretion as to the number of points that they score. If the defense happens to disagree with that calculation, that should be brought to the judge's attention at sentencing, and ultimately the judge will make the decision as to the number of points that should be scored. So let's generate another true-false question here pertaining to victim injury points. Now, true or false, permanent victim injury points should be scored for offenses involving photographic or video evidence of child pornography. I'm going to go ahead and launch this poll question here. I'll read it one more time while you all start making selections. So true or false, permanent victim injury points should be scored for offenses involving photographic or video evidence of child pornography. Give you all just a couple seconds to think about it and make a selection. About 5 more seconds here. Okay, so let's go ahead and take a look at the results. So 66% think that this is true and 34% think this is false. So let's go ahead and take a look at the answer. So the answer is true. We actually did add language to our manual pertaining to permanent victim injury points related to photographic or video evidence of child pornography. And this language was added and was intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography and is not limited to convictions for the possession, manufacture, or distribution of child pornography. So for instance, this rule may also apply in cases involving the following types of offenses if evidence of child pornography is present. That being sexual solicitation of a minor, sextortion, visual and camera surveillance of a public place, obscene matter, prostitution, human trafficking, or electronic harassment. Now, the scoring of permanent victim injury points recognizes that the photographic and video evidence of child pornography often exists in perpetuity, and the victims of these cases suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. So if you're ever calculating guidelines for a case that does involve this photographic or video evidence of child pornography, permanent victim injury points should be scored in that instance. So moving on to weapon presence, which is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. Now, I do want to note when calculating the offense score as a whole, a judge may include factors known to the judge when making this decision, even if they are not within the scope of the convicted offense. So, for example, if you have a defendant who is charged with armed robbery, if they ultimately plead to robbery, points may still be awarded for firearm or weapon presence in that scenario. We have another poll question here. So does gasoline or a lighter constitute an explosive as it pertains to weapon presence points? I'm going to go ahead and launch this poll. And I'll read it one more time. So for the purposes of scoring weapon presence points, does gasoline or a lighter constitute an explosive? Maybe I'll just a couple more seconds here. All right, so let's go ahead and share the results here. This one's pretty split. This is 53% thinking true and 47% thinking false. Or I'm sorry, 53 think yes, 47 think no. So let's go ahead and take a look at the answer here. So the answer is no. Let's look at a recent update that clarifies these instructions here. Now, in response to multiple inquiries asking whether the presence of items designed to start a fire, such as gasoline and a lighter, would constitute an explosive as it pertains to weapon presence points, the commission reviewed this issue and decided to clarify that the offense score instructions to reference the definitions of explosive and incendiary materials provided in Criminal Law 4-501. So the revised instructions with the added language that you see in bold here indicate that the individual completing the worksheet shall assign a score of 0 if no weapon was present, a score of 1 if a weapon other than a firearm was present, or a score 2 if a firearm or explosive material was present. Further, the following rules regarding weapons shall apply. First, explosive material as defined in Criminal Law 4-501 is considered the same as a firearm. And second, weapons other than firearms include incendiary and toxic materials as defined in Criminal Law 4-501. knives, tire irons, and clubs. So based on this clarifying language, the presence of gasoline or a lighter would constitute a weapon other than a firearm, that being incendiary material, and would be awarded 1 point for weapon presence. So hopefully that helped to provide some clarification regarding the scoring of that material. All right, so before we look at special victim vulnerability, gonna generate another poll question here. So would a victim who is known by the defendant to be intoxicated meet the criteria for a vulnerable victim? Let me go ahead and launch this poll. So would a victim who is known by the defendant to be intoxicated meet the criteria for a vulnerable victim for the purposes of scoring special victim vulnerability? Give you all just a couple more seconds here. All right, looks like majority have locked in. So 70% think yes, and 24% think no. So let's go ahead and take a look at the answer here. And the answer is yes. So let's take a look at the criteria and the factors that are used to determine if a victim is especially vulnerable. So 1 point should be scored for special victim vulnerability if the victim is younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who's physically or mentally limited in a material way. Examples of a temporary physical or mental limitation include, but are not limited to, instances when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. So again, if the circumstances meet this criteria, then 1 point would be scored for special victim vulnerability. So that wraps up the offense score. The next section we're going to discuss is the offender score. Now, the offender score is a summary scale ranging from 0 to 9, which measures an offender's criminal history, taking into account 4 factors. That being the relationship to the criminal justice system when the instant offense occurred, juvenile delinquency, the prior adult criminal record, and prior adult parole and probation violations. So we have another true false before we take a look at part A, relationship to the criminal justice system when the instant offense occurred. So true or false, 1 point should be scored for part A of the offender score, the relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. Let's go ahead and launch that poll question here. This is probably one of the most common questions that we receive, so I always like to highlight it in trainings. So true or false, 1 point should be scored for part A of the offender score, the relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. I'll give you all just a couple more seconds here. Okay, looks like majority is locked in. So let's go ahead and take a look here. All right, so this is pretty split. 57% think that this is true and 43% think this is false. So let's take a look at the answer here. Now, the answer in most cases is going to be false. So let's take a look at why that is. Now, the offender should receive 1 point for being in the criminal justice system. For example, if the defendant's currently on parole, probation, etc., as a result of an adjudication of guilt at the time the instant offense was committed. So generally, being on pretrial supervision, the defendant has not yet been adjudicated guilty, which is why normally a point would not be scored for part A of the offender score if the defendant was on pretrial supervision. However, it has been brought up in past trainings that it's possible the defendant was on pretrial supervision, was adjudicated guilty, and then remained on pretrial supervision while pending sentencing. So if the defendant had picked up this instant offense after the point of being adjudicated guilty and pending sentencing, then a point would be scored for being in the criminal justice system as a result of an adjudication of guilt. But again, otherwise, being on pretrial supervision generally would not meet this criteria, meaning that a point would not be scored for part A of the offender score. So moving on to juvenile delinquency. So 0 points are scored for juvenile delinquency if the offender is 23 or older by the date of the most recent instant offense, or if the offender has 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under 23 and has had 1 or 2 findings of a delinquent act within 5 years of the date of the most recent instant offense, and 2 points scored if the offender is under 23 and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. I'm sorry, I forgot to mention one last thing with regards to the scoring of Part A, and I want to mention it before I forget. So I do want to note that this particular component of the offender score is scored at the offense level. When you do have multiple criminal events or multiple offenses that are being sentenced as part of the same sentencing event, if they span a long period of time, which can be the case, it's possible that the defendant was on some type of criminal justice supervision when one of the offenses occurred, but perhaps not when the other offense occurred. And that is why this particular component is scored at the offense level. So it's possible for that score to vary across offenses in a sentencing event. Just wanted to clarify that. Okay, so moving on to some additional instructions pertaining to the scoring of the juvenile delinquency. I do want to note that only 1 finding of a delinquent act, that being the finding of facts sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing. So this is similar to how the adult prior record is calculated. But for instance, if you had a defendant who was charged with robbery and possession of a firearm as a youth, happened to be adjudicated for both of those offenses during the course of 1 adjudicatory hearing. For the purposes of calculating and scoring the juvenile delinquency record, you would only count 1 finding of a delinquent act, not 2. And when the defense or the state can show that a finding of a delinquent act did not result in the youth's adjudication as delinquent at a juvenile disposition hearing, that finding of a delinquent act shall not be scored as part of the juvenile record. Finally, just want to note that effective October 1 of last year, we did add a revision providing the additional instruction that the juvenile delinquency record may not include adjudications based on acts that are no longer crimes. And this revision is consistent with the instructions for scoring the prior adult criminal record, which again state that the prior adult criminal record shall not include adjudications based on acts that are no longer crimes. So moving on to prior adult criminal record, aside from a few exceptions that we have further noted in our manual, so this can include violations of local laws, adjudications based on acts that are no longer crimes. Generally, the prior adult criminal record includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. So we have another true-false question here. So true or false, only 1 adjudication per criminal transaction should be counted towards the prior record score. Let me go ahead and launch this poll here. So true or false, only 1 adjudication per criminal transaction should be counted towards the prior record score. Give you all just a couple seconds here. All right, looks like we have majority vote. So let's go ahead and share those results. So 64% think that this is true and 36% think false. So let's take a look at the answer here. Now the answer is true. Only 1 adjudication per criminal transaction should be counted towards the prior record. So let's break down that calculation of the prior record in greater detail, because this is probably the most complicated component of the offender score. Now, the first step when reviewing a defendant's prior criminal history is to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications that stem from the same criminal transaction, you're only going to account the offense that has the highest seriousness category towards the scoring of the prior record. Step 2 is then to count the number of offenses in each seriousness category, using only those offenses that you identified in step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level. We're going to walk through an example of how to calculate the prior record in a moment here. Before we do, I do just want to note that Maryland allows for what we refer to as the criminal record decay factor, meaning that if a defendant has remained free of criminal justice system involvement, so meaning they have been off parole, probation, mandatory supervision, etc., for 10 years prior to committing this instant offense, the criminal record should be reduced by 1 level. So if you initially calculated it to be a moderate, but if the defendant's been off parole, probation, etc., for 10 years prior to this instant offense, that criminal record level would be reduced to a minor. So let's take a look here. Here's a screenshot of our prior adult criminal record, which is what you will be referring to calculate that prior record level. And let's walk through a hypothetical prior criminal history here. So let's say we have a defendant who back on October 1st of 2013 was convicted of second-degree assault, which is a seriousness category 5, and aware carry transport, which is a seriousness category 7. Now, since I have 2 convictions that stem from the same criminal transaction, I'm only going to count the most serious offense here, the one with the highest seriousness category, which would be the assault second degree, with it being a 5. Then on July 28th of 2016, the defendant was convicted of burglary second degree, which is a category 4. And then on December 12th of 2020, convicted of destruction of property, which is less than 1,000. Now, I'm counting these 3 convictions towards the scoring of the prior record. So when looking at their seriousness category classifications, I can see that the burglary second degree, that being the category 4, is the highest seriousness category among all of these convictions. So then I'm going to look to my prior adult criminal record matrix here. I'm going to look to the seriousness category on the category column on the left-hand side here. Again, since the seriousness category 4 is the highest seriousness category among my convictions, I'm going to look to the seriousness category 4 row. And then up top here, these columns list the number of convictions within that seriousness category. So looking at seriousness category 4, I only have 1 seriousness category 4 conviction, which means I'm going to look to this first box here. So I can see initially this would be calculated to be a moderate record level, but would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any 6 offenses in general. So hopefully walking through that example helped kind of all of that fall into place. Again, I know that that can be a complicated component to calculate. If you ever have questions about calculating the prior record, please always feel free to reach out to us. We're happy to help with that. And then wrapping up with part D, that being prior adult parole and probation violations. So 1 point would be scored if the offender was ever adjudicated in violation of parole and probation, or if they were convicted of an offense while on parole and probation, unless that adjudication or conviction arose from the offense or offenses of this sentencing event. All right, so moving on to the next section that we see highlighted here. This captures the recommended guidelines range. When reviewing the worksheet, you'll see there's space for each individual guidelines range for each convicted offense, and then the overall guidelines range populates at the bottom here. So based on how you enter information into the system, MAGS is going to calculate those recommended ranges for you. Let's just take a look at a couple of examples that show how the guidelines range is adjusted due to special circumstances in a case. So here's an example of where the overall range is adjusted due to a case involving multiple victims within a criminal event, which we refer to as our guideline stacking rule. Now, in this type of case, the guidelines range for each individual offense is still calculated as normal. But instead of using the highest of the upper limits and the highest of the lower limits, instead, it's the highest of the lower limits that's taken and the upper limits, for each offense per unique victim is then added or stacked to increase the overall guidelines range. So here in this example, we can see that the defendant was convicted of 3 counts of assault second degree. We can see the multiple victim stacking rule was applied for all 3, indicating that this involved 3 separate victims. Now I'm going back to basics here. For those of you who've been utilizing the guidelines for years, you might remember when you were manually calculating them, that in a scenario like this, where you have one criminal event with not more than one seriousness category 1 or 2 offense, generally you're taking the highest of the lower limits here and the highest of the upper to get the overall guidelines range. But in a case like this, where you have multiple distinct victims, you would then take the highest of the lower, which would be 2 years since they all have the same individual guidelines range. But instead of just taking the 5 years to get the overall range, you would then add or stack together the upper limit for each offense involving a unique victim, which would then increase the overall guidelines range to 2 years to 15 years to indicate that the case did involve multiple distinct and unique victims. So let's recap the criteria for applying the stacking rule. 1, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense, which if you did try to apply the stacking rule that didn't meet this criteria, MAGS would actually disable you from flagging it. Further, 1 convicted offense per distinct victim may be used to calculate the overall guidelines. So if you have multiple offenses related to the same victim, you would want to flag the offense with the highest seriousness category for the purposes of applying the stacking rule. And again, it's only the upper limits that stack. We have another true-false here. So true or false, the stacking rule can only apply towards person offenses. So we talked about those earlier. Those are the ones that have the offense score calculation. True or false, the stacking rule can only apply to person offenses. I'm going to go ahead and launch the poll here. I'll give you all a couple seconds. True or false, the stacking rule can only apply to person offenses. All right. Let's go ahead and share the results here. I always like highlighting this question because it's always very close to a 50-50 split. So we have 48% thinking this is true and 52% think this is false. So let's go ahead and take a look at the answer here. Now the answer is false. So the stacking rule can definitely be applied towards property offenses as well. So for example, if there are multiple victims that pertain to like a theft or a theft scheme or fraud related case, you can certainly apply the stacking rule in that scenario as well. It is not limited to solely person offenses. All right, let's look at another example here in which the overall guidelines range is adjusted. So in this example, we show a case where the offender was convicted as a subsequent drug offender pursuant to criminal law article 5-905. So in this example, the defendant was convicted of distribution of cocaine, which is a category 3B. With the hypothetical offender score of 3, that guidelines range is initially calculated to be 3 months to 3 years. However, pursuant to criminal law article 5-905, the defendant's being convicted as a subsequent drug offender, that statutory maximum then doubles from 20 years to 40 years. And by guidelines rule, the guidelines range also doubles. So in this case, while it would initially be 3 months to 3 years as the overall guidelines range, applying this enhancement would increase the overall guidelines range to 6 months to 6 years. All right, so that wraps up the different scenarios here. Wrapping up with the different sections of the guidelines worksheet, the section that you see highlighted here is victim information. These are questions that pertain to the rights of victims at sentencing, and again, are located in this bottom left-hand corner. I'll talk a little bit more about that when we get into the MAGS demonstration. And then finally, the last screenshot that you see here, these fields that you see highlighted in yellow, these are typically the sentencing and departure related fields that are typically completed by judges and their designees post-sentencing. So that obviously includes the individual sentence information for each convicted offense, the disposition type, etc. All right, so next we're going to review how to determine if a sentence is a guidelines compliant sentence. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, falls within the applicable guidelines range. So I do want to note that generally suspended time is not considered when determining whether a sentence is compliant. There's one exception involving corrections options, which we'll talk about later, But again, generally, it's that sum of incarceration, credited time, and home detention time that's used to determine compliance. Now, I do want to note that compliance is calculated by comparing the overall total sentence across all convicted offenses in a sentencing event to the overall guidelines range for that sentencing event. So, for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in a sentencing event, fall below the lower guidelines limit for a second offense, but the overall sentence, when adding together the sentence for both counts, taking into consideration whether they're running concurrently or consecutively, it could still fall within the overall guidelines range for that sentencing event. Now, there are a few qualifiers to consider regarding guidelines compliance. And the first is that effective April 1 of 2021, sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. Now, some of you who may have been utilizing the guidelines for years at this point, you might remember the former ABA plea agreement disposition type that we had. But I do want to note that that former ABA plea has been replaced with MSCCSP binding plea agreement. And the criteria for what would constitute a guidelines compliant MSCCSP binding plea agreement has also been revised. We're going to look at that criteria in a moment. Just to note that the MSCCSP binding plea compliance rule, it follows the same logic as that former ABA plea agreement compliance rule, which was initiated based on feedback that we received from the judiciary that binding pleas represent a consensus of the parties in the court within their specific community. And accordingly, the commission felt it was important to define these as compliant sentences. Now, binding pleas are three-party agreements in which the state and the defense present to the court on the record an agreement that incorporates a specific sentence. If the judge accepts that agreement, it becomes binding on the court pursuant to Maryland Rule 4-243, subsection C. Now, following a review of binding pleas in 2020, the commission ultimately agreed that that former ABA plea agreement term was not universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. And further, effective April 1 of 2021, the commission narrowed the definition of what would constitute a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. So in totality, the definition of an MSCCSP binding plea agreement is a plea agreement presented to the court, an agreement by an attorney for the government and the defendant's attorney, or the defendant when proceeding pro se, that a court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and it becomes binding on the court under Maryland Rule 4-243, subsection C, if the court accepts the plea. Now, I know that's a lot of information to take in, so let's take all of that and apply it to some hypothetical sentencing scenarios. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? So I'm going to go ahead and launch this poll question here, and I'll read it again as you all start making some selections here. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? Give you all just a couple seconds here. All right, looks like we have majority, so I'm going to go ahead and share the results. So this is pretty split. We have 46% think yes and 54% think no. So I'm going to go ahead and look at the answer here. So the answer is no. So as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range anywhere from probation to 2 years. This is why it would not constitute an MSCCSP binding plea agreement, because it involved a range. So let's look at another scenario here. Let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? I'm going to go ahead and launch that. I'll read it one more time. So the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? About 5 more seconds. All right, let's go ahead and take a look at the answers here. All right, so 90% think yes, 10% think no. So let's go ahead and take a look at the answer here. So yes, this would constitute an MSCCSP binding plea agreement. In this scenario, there was an agreement to a specific amount of active time, that being 0 or no post-sentence incarceration. Therefore, this type of agreement would constitute an MSCCSP binding plea agreement. So that's the difference between the two scenarios. This one involving a specific amount of active time, if any, whereas the first scenario involved an agreement to a sentence range. And then wrapping up with one more scenario, this isn't going to be a poll question. Let's just walk through this sample scenario. Let's say the guidelines for this sentencing event are 1 year to 5 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. While this agreement is not an MSCCSP binding plea agreement, right, because the agreement involved a sentence range again, the sentence itself is still guidelines compliant, since the guidelines applicable sentence of 2 years is falling within the overall guidelines range of 1 year to 5 years. So all that to say, it's absolutely possible to have a guidelines compliant sentence that is not adjudicated via an MSCCSP binding plea agreement. Just something to keep in mind is if there is that 3-party binding agreement to a specific amount of active time, that would constitute an MSCCSP binding plea agreement, which would be deemed guidelines compliant automatically. All right, so moving on to an additional qualifier regarding guidelines compliance to consider, that being the role of corrections options. So sentences to corrections options programs, that being drug court, residential substance abuse treatment, etc., those are deemed compliant, provided that the initial sentence plus any suspended sentence. So essentially, as long as the total sentence falls within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. So this is the exception I mentioned earlier, in which suspended time is considered for determining if a guidelines compliance sentence. Now, corrections options, they allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. Corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under a Health General 8-505 or 8-507 order, drug court, participation in any problem-solving court. That includes sentence participation. So for example, if there's participation in drug court prior to sentencing, that would still constitute a corrections option program. A sentence with required substance abuse treatment for the possession of CDS, work release, or weekend or other discontinuous incarceration. So if a corrections option program is utilized, you could technically have a fully suspended sentence be compliant with a recommended guidelines range of 1 year to 5 years, say, as long as that total sentence is falling within or above that 1 to 5 year range. So again, it does allow judges to utilize a broader range of alternative to incarceration while still remaining compliant with the guidelines. And then finally, the last rule regarding calculation of guidelines compliance. is sentences in which the offender received credit for time served with no post-sentence incarceration. And if that amount of credited time exceeds the guidelines range, it's deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months, the sentence is 6 months fully suspended with credit for 100 days. The sentence would still be guidelines compliant, even though that credited time exceeds that upper guidelines limit of 3 months. All right, so we're going to be moving on to our demonstration of MAGS. Before we do, I just want to quickly note our guidelines calculator tool, which can be accessed through our website by clicking this GLCT icon. Now, our guidelines calculator tool, it's a standalone tool that can be utilized by anyone to calculate sample sentencing guidelines. It's essentially a simplified version of MAGS. So you'll see this offender information, offender score, list of offenses. It looks identical to the tabs that you would see in the MAGS application. However, this tool, it doesn't require a user ID or password. The only caveat is that once you utilize the tool, it doesn't save any of the information to the tool itself. So you want to make sure before closing out your browser that you're saving a PDF or printing it out. I want to point out this tool specifically to any defense attorneys who may be attending this training. This would be a very helpful tool for you to calculate sample sentencing guidelines. As I mentioned, it mirrors the MAGS demonstration, so please stick around for the MAGS demonstration as it pertains to utilizing the guidelines calculator tool itself. Also pointing it out to any state's attorneys, parole and probation agents who just simply want to use the tool to calculate sample sentencing scenarios. I know a lot of prosecutors do use the tool initially to kind of go through different scenarios, prior to plea negotiations or what have you. So if this tool would be helpful to you, please check it out. But ultimately, we do need you to officially initiate the guidelines worksheet in the MAGS system. So here's a screenshot of our MAGS homepage here. From that homepage, you can simply click on the MAGS login button to get to MAGS. We also have various instructional and support materials here for you all. We have a user manual. If you click on it, it's a very detailed PDF with screenshots. If you ever have a question about MAGS, you'll probably find the answer in that manual. We also have 2 instructional videos. First one is geared towards state's attorneys and parole and probation agents and focuses on how to initiate a guidelines worksheet, very similar to what I'm going to be showing you in a minute. The second video is geared towards judges and their designees and focuses on entering sentence information and ultimately submitting worksheets through the system. So if you ever need a refresher, if you have a new colleague who comes on board, we would encourage them to check out those videos. Okay, so at this point in time, I'm just gonna go ahead and bring up my MAGS screen. Just bear with me one moment here. Okay, so hopefully you all are seeing the MAGS login screen now. Now, in terms of user ID or password, everyone's user ID involves a prefix that corresponds to your individual agency or jurisdiction. For most state's attorneys, it's probably your 2-digit jurisdiction code, then SAO / followed by some combination of your first and last name, and then most often your work computer password. In some jurisdictions that's different, and a password is provided to you. Parole and probation agents, yours is MDCS with a / followed by your work computer username and password. Any public defenders who are attending this training, you all have read-only access to worksheets in MAGS. That's just to avoid an issue of duplication. If there were multiple parties able to officially initiate worksheets in the system, it gets confusing for judges and their designees to know which worksheet to ultimately submit. So that said, you all do have read-only access to the system, and then you could utilize the guidelines calculator tool to calculate your own sample guidelines. Your user ID would be PUBD and then a /, again, followed by your work computer username or password. Any defense attorneys who may be attending this training, we are able to create a MAGS account for you that would allow you read-only access to the worksheets initiated in the system. So if you're interested in that, please just send an email to our general email account and I will provide instructions for how to set that MAGS account up. So to start, I'm just going to go ahead and enter my login credentials here. Okay, So after logging in, I'm going to be brought to the home screen here. From the home screen, this is where users create a new worksheet, or you can view, edit, or delete an existing one. Now, many of you are going to be initiating brand new worksheets. However, it's important that you're searching the system to make sure that you're not duplicating a worksheet. This is especially true with state's attorneys and parole and probation agents. It's possible that the state had initiated a guidelines worksheet only for a pre-sentence investigation to then be ordered, in which case it would be parole and probation who's responsible for initiating the worksheet. So in that case, let's say that was the case. State's attorney initiated a worksheet, parole and probation, searched the system, saw that a worksheet had already been initiated. The investigator can view the worksheet. If they agree with the state's calculation of the guidelines, you could just leave the worksheet as is. However, if parole and probation views the state's calculation and disagrees or has questions about the calculation of the guidelines, instead of duplicating just a second worksheet, we do ask parole and probation to reach out to the state's attorney or vice versa and discuss those discrepancies in hopes of coming to a consensus. That way, any changes that need to be made can just be made to that one record in the MAGS system. That way, we don't have duplicate worksheets that have different calculations, where, again, it gets confusing for judges and their designees to know which one to ultimately submit. So a couple of different ways you can search the system. You can search entirely by jurisdiction. You can enter the defendant's state identification number, the first name, last name, or case number associated with the defendant, or you can search by the worksheet ID number here. Now, if I went ahead and searched for a Jane Johnson case, a test case that I already created here. So you can see once I do that, I have two different case numbers populating, one ending in 1122 or one ending in 1133. I can see they have the same sentence date of September 15th here. And if I were to look at this worksheet ID field, I can see that they both share the same worksheet ID, that being the 145675. So if I were just to search that worksheet ID, from the beginning, this is the search result that would come up since both of these case numbers are linked. Now, I'm going to sound like a broken record by the end of this training, but again, just to reiterate, when you have multiple criminal events that are sentenced by the same judge on the same day, they constitute one sentencing event. And when you go to initiate the guidelines worksheets in the system, you would only want to click this add new button one time. You don't want to create a separate worksheet for each separate case number. If they are being sentenced as part of the same sentencing event, you should click that add new button one time. And then when we get to the list of offenses tab, that's where I'm going to show you in a moment here. That's where you would add all of that unique case number and criminal event information. Now, if they're initiated properly, they will be linked by the same worksheet ID. That's what we want. What happens if you were to initiate multiple criminal events that are a part of the same sentencing event, if they were initiated separately? Two issues. The first major issue is that the judge isn't presented with a correct and accurate overall guidelines range, because they do need to be combined in order to present an accurate overall guidelines range for that entire sentencing event. The second issue comes into play when judges and their designees go to submit these worksheets. They'd be able to enter sentencing information, but if these had two different worksheet ID numbers, they'd be able to successfully submit the first worksheet. But when they go to submit the second worksheet, they're going to get a duplicate error message saying there's already been a worksheet submitted that contains the same SID number, date of birth, and date of sentencing, which means that they would have to contact our staff. We have to combine them under one worksheet ID and then send them back a revised PDF. So all that to say, again, I know I'm going to sound like a broken record, but make sure when you have multiple criminal events as part of the same sentencing event that you initiate them under one MAGS record. Okay, so let's say we searched the system, didn't find the case that we need to initiate guidelines for. So to begin, you would simply click this add new button here. Once you do that, it's going to prompt you as a reminder just to search the system to make sure a worksheet hasn't already been initiated. And again, only one worksheet should be created for multiple event or offense cases sentenced on the same day by the same judge. So you would simply click OK. So rather, if you're editing a previously initiated worksheet or creating a brand new worksheet, you're always brought to this offender information tab first. So you can see we have MAGS divided into 8 tabs, each of which represents a different section of the guidelines worksheet. Now, these first 4 tabs here, that being the offender information, offender score, list of offenses, and victim information, those are typically the tabs that are completed by the state and parole and probation, and the defense if you were to calculate your sample guidelines prior to sentencing. So I'm just going to start with offender information, pretty self-explanatory. This is where we're capturing basic demographic information about the offender, as well as the worksheet prepared. Just one thing to note, throughout MAGS, you'll see these red asterisks. These are mandatory fields, meaning you have to enter some sort of value before ultimately submitting the page and moving on to the next tab. Also, throughout MAGS, you'll see these information icons. If you click on the icon, it gives you a more detailed explanation of what we're trying to capture in that field. So all of the information in those icons, it's taken directly from our guidelines manual. So again, if you ever have a question about what we're trying to capture, please utilize those icons. They are extremely helpful. So I'm just going to begin with the worksheet preparer here. My name, and then my title or agency. And then beginning with the defendant's last name, first name, middle name. Now, state identification number. Now, I do want to note that it's important that you're referring to the rap sheet, whatever type of documentation that you have that gives you an accurate SID number, and making sure that that SID number is entered into the MAGS system. That is a field that we use to merge our data with other data sources in order to run various analyses. So it's important that if the defendant does have a SID number, that SID number is entered accurately. That said, we know there are some scenarios where perhaps the defendant hasn't been fingerprinted yet, in which case they would not have a SID number. In that case, we do provide guidance to enter basically like the number 9 7 times, but that should only be utilized when there is no SID number. Please do your best to try to find the SID number when entering in that field. Moving on to the sex here and date of birth, again, pretty self-explanatory. Whether a pre-sentence investigation was ordered, the jurisdiction here, representation, say public defender, ethnicity, unknown, and then race. I do want to note that it allows for multiracial responses here. So you can check as many boxes as applicable, and then we would click save this page here. Now you can either move forward by clicking the next button, or you can simply click on the header of the next tab here. So moving on to offender score, we already went through all these components, so I'm not going to spend time going through them. I noted earlier that relationship to the criminal justice system when the incident offense occurred, that's scored at the offense level. So you're not going to be scoring it on this tab. We're going to score it when we get to the next tab. So you would then make selections for juvenile delinquency. Just want to note for prior adult criminal record, if you hover over this, it's actually a clickable link, which brings you to our matrix. And then if you scroll, it details all of the various criteria for scoring the major, minor, moderate record, etc. Now, if you need to apply that decay factor that we talked about, so let's say in this case, I initially calculate this to be a major record, but the defendant meets that criteria for the criminal record decay factor. So as soon as I click yes, you'll see that this jumps down to a moderate. And then when we view the worksheet, you'll actually see decay factor populate in red text to indicate that the decay factor was applied here. And then 0 points for prior adult parole and probation violations. So I'm going to click save this page and move on. So list of offenses, this is where we're going to add all of the convicted offense information. And when you do have those multiple criminal events, as long as they're a part of the same sentencing event, you're going to be entering all of that unique case number information on this tab. So in this test case, I'm going to show you how to enter 3 convicted offenses with 2 criminal events total. So to begin, I'm just going to quickly click add offense here. In the upper left-hand corner, this is where you start with the event number. So when you do have multiple criminal events, you want to make sure you're properly noting the criminal event number, as that factors into how the overall guidelines are calculated. So to begin, I'm going to say this is event number 1. The count number, you would want to list the count number that corresponds to the offense as it's listed on the indictment. So instead of just listing all of these in a sequential 1, 2, 3, 4 order, please list the count number that corresponds to the offense as it's populated or reflected on the indictment. So let's say this is count number 3, and I have an offense date of May 1st of this year. So based on the jurisdiction I select, you'll see that it pre-populates with the MDEC format related to that jurisdiction. So I selected Anne Arundel, so I see a C02CR. Following that, you're going to enter the 2-digit filing year. And then following that, there needs to be a 6-digit sequential number. So let's just say I have like 4 zeros and then a 1 1 here. Now, searching for the convicted offense title, there's 2 different ways you can search. You can click this most common offenses button, which brings you to our 25 most common guidelines eligible offenses. Or you can click the search button, which brings you to our entire offense table. Within the offense table, you can search further. So you can type in the offense title in this box here, the CGIS code, statute, or the type. So whether that's person, property, or drug. In the upper left-hand corner, you can simultaneously search all of those fields. So for example, if I was trying to locate an assault 2nd degree, as soon as I start typing this, the word assault here, any offense that contains the word assault would populate here. And I can quickly jump down and select assault 2nd degree here. So once I do that, you can see that MAGS populates the seriousness category, the CGIS code, the statute, statutory maximum, or the mandatory minimum if there were one here. Now, we talked earlier how generally any attempt, conspiracy, or solicitation, it's going to be assigned the same seriousness category as the underlying offense. So generally, you would just be selecting the underlying offense, in this case, that being the assault 2nd degree. And then if this happened to involve a conspiracy, I would just simply check that radio button. I mentioned the exception to that rule involving the more serious offenses. So I just want to quickly bring up the offense table, and I'm going to type in murder here. You can see once I do that, how the attempt, conspiracy, and solicitations associated with that murder, how they're listed as separate offense entries. So if you do have a case with involving some of these more serious offenses that also involves an attempt, conspiracy, or solicitation, that's where you want to make your selection. In fact, if you were to select murder 1st degree and then tried to hit the radio button underneath it, MAGS wouldn't allow you to do that. So this is where you would make that offense selection. Now, jumping down to enhancements here, if I were to click this drop down, this is where that subsequent drug offender enhancement that we talked about could be applied, or if the defendant's being convicted as with a subsequent crime of violence and therefore subject to a 10, 25-year life mandatory minimum, or if the defendant's a repeat sex offender and they're subject to a life maximum, you would apply that enhancement here. If the offense you selected, if none of these enhancements can apply to that particular offense, you'll actually see all of these disabled, which is the case with the assault 2nd degree. But if the offense you selected does allow for one of these enhancements, it would become enabled. So jumping down to the multiple victim stacking rule. So let's say I was calculating guidelines for a case that involved like multiple convictions for assault 1st degree, and I wanted to flag them since they all involve separate victims. I would just simply click yes for flagging the offense for the multiple victim stacking rule. And it would just remind you of when the stacking rule can be applied. Also to remind you that in order for the upper guidelines limits to stack, that the flag must be applied to at least 2 offenses within a given criminal event, each with a unique victim. So the test case I'm showing you all today, it's not going to meet that criteria, so I'm not going to go ahead and flag that right now. Jumping down to offender score, relationship to the criminal justice system when the instant offense occurred. I mentioned several times that this is scored at the offense level. So this is where you would make that selection. And then based on the selections that you made for juvenile delinquency, prior adult criminal record, etc., on that offender score tab, that pre-populates here. Now, moving on to the right-hand side, this is the offense score. We talked about how that should be completed only when the case or when the offense is a person offense. So assault 2nd degree does meet that criteria. It's a person offense, which means I need to make those calculations. So part A, the seriousness category, MAGS will calculate that for you just based on the seriousness category of the underlying offense that's selected. And you would then go on and make selections for victim injury. So I'll select injury that's non-permanent with no weapon present, and the defendant did not meet that criteria for special victim vulnerability. Once I do that, you can see MAGS populates the total offense score and offender score for you. And I'm simply going to click calculate guidelines range. It gives me the individual guidelines range for the offense, and then the overall guidelines range for the sentencing event would be updated there as I continue to add offenses. So I'm going to click save this page and close here. And then I have all of my convicted offense information for this assault second degree. Now, the next offense that I'm going to add, it's going to correspond to a different case number. It's going to be a second criminal event, so it's going to have a different case number, which occurred on a different offense date, which is why I'm considering it a second criminal event. Now, I'm still going to add that information on the list of offenses tab. I'm going to click the add offense button again, except this time I'm going to make sure to note that this is criminal event number 2. And then let's say this is count number 1 within that criminal event number 2. So it's going to have a different offense date than the one I just entered. So let's say this is June 15th of this year. And it's also going to have a different case number than what I just entered. So we'll do 23, 1, 2, 3, 1, 2, here. All right, so I'm going to click most common offenses. Oops, added an extra number here. So I'm going to click the most common offenses button here. And I'm searching for a burglary first degree, which I can easily find from that list of most common offenses. Now, burglary first degree, I'm just going to jump down to the offender score and make my selection for the relationship to the criminal justice system. Burglary first degree is a property offense, so it does not require an offense score calculation, so you'll see that that's disabled. So you would simply just jump down and click calculate guidelines range, and we can see that overall guidelines range for the sentencing event has now increased since I added that second criminal event here. So I'm going to click save this page and close. All right, so there I can clearly see at this point I have 2 separate criminal events, 2 unique case numbers, their individual guidelines range for each offense, and then that overall guidelines range for the sentencing event. So I'm just going to quickly add one more offense. So this is going to be a theft-related offense that's a part of that criminal event number 2 that I just entered. So this is going to be criminal event number 2, but it's going to be count number 4 within that criminal event. So it's going to have the same offense date as the one I just entered and that same case number, the 1342. So I'm going to click most common offenses here. And again, I'm searching for that theft, and it's this theft less than, or at least 1,500, but less than 25,000 that I want to select. Again, I'm going to jump down and click 0 for relationship. This is, again, is a property offense, so I can simply just jump down to calculate guidelines range and then save this page and close. And there I have all of my convicted offense information. Again, clearly noted that there are 2 separate criminal events here. Now, the last tab that needs to be completed prior to sentencing would be victim information. I mentioned earlier that this pertains to the questions pertain to the rights of victims at sentencing. You can feel free to utilize these icons. It details what we're trying to capture here. If there's no victim in the case, you could simply select no, and you'll see that all of these fields populate as no. If there is a victim in the case, then we do ask you to make these selections as appropriate. That said, there are some fields that may not be able to be completed until after sentencing. For example, whether the defendant was present at sentencing, if they gave a written or oral victim impact statement. So in that case, we do ask judges and their designees to complete those fields post-sentencing. Okay, so at this point in time, I've completed all of the tabs that need to be completed prior to sentencing. So to view the worksheet, you would just click the View Worksheet PDF. And here, I mentioned at the beginning of the training, when you have multiple criminal events, how each separate criminal event should correspond to their own worksheet here. So here I have the assault second degree, the conspiracy pertaining to that 1-1 case number. And then if I were to scroll, I can see the burglary and the theft pertaining to criminal event number 2 with that own unique case number of 1342. However, there's still one overall guidelines range of 6 months to 5 years calculated between them. And from here, you could save the PDF, print it out, and bring it to sentencing, whatever you prefer. Now, the last thing I just want to note before we wrap up this MAGS demonstration, I'm just going to jump back to the list of offenses tab. I noted in the beginning of the training that when you have merged or null prost offenses, how those should be removed from the guidelines. Ideally, we do ask that you do this prior to judges and their designees getting in and entering sentence information. So to delete an offense from the list of offenses tab, for example, let's say that this theft ended up being merged or null prost at sentencing, you would simply click the trash can icon and it will confirm that you want to delete this offense, and you click OK. Now, if deleting an offense happened to alter the overall guidelines recalculation, MAGS would automatically recalculate that for you. It tends to be the lesser offenses that are merged in null pros, so it normally doesn't affect the overall guidelines calculation, but if it did, MAGS would recalculate that for you. And then you would click Save This Page. Okay, so that wraps up the MAGS demonstration. I know we're moving quickly, but we had a lot to cover. I'm just going to wrap up really quick with some brief highlights, and we should be done. Let me just go ahead and pause this real quick. Give me 1 second to bring this PowerPoint back up. All right, so before we conclude, I'm just going to quickly highlight some recent updates to the sentencing guidelines. The first is that effective January 1 of 2023, the maximum penalty for violations of criminal law 5-602B1 and 603B, so that being unlawfully possessed with intent to distribute, manufacture, possess production equipment of cannabis, that penalty decreased from 5 years to 3 years. And accordingly, the commission voted to change that seriousness category from a 4 to a 5. So this seriousness category revision was adopted April 1 of 2023, at which time those corresponding offense entries for violations of criminal law 5-602B1 and 603B in MAGS were also revised. So also just something to keep in mind when scoring of the prior record here. So if you are calculating the prior record and one of the offenses is for this unlawfully possessed with intent to distribute, manufacture, possess production equipment of cannabis, please remember that you should be using the revised seriousness category of 5 as opposed to the old seriousness category, which was 4, because it's the seriousness categories in effect at the time of sentencing that should be used to calculate the prior record. So these cannabis penalty changes, they also impact the prior record calculation of the offender score. Specifically, per guidelines rule, we mentioned adjudications based on acts that are no longer crimes should be excluded from the prior record. So as such, cannabis possession should accordingly be excluded from the calculation of both the juvenile and prior adult criminal record if it can be determined that a prior adjudication for cannabis possession involved 2.5 ounces or less, or if the defense has been expunged from the record or proven by the defense to have been eligible for expungement as a matter of right prior to the date of the offense. So unless otherwise eligible for expungement, calculation of the prior record remains unchanged for possession involving more than 2.5 ounces of cannabis, as this offense remains punishable by up to 6 months of incarceration and or a $1,000 fine. So just something to keep in mind. Also, just want to note that as required by the enactment of Chapter 141, Acts of 2022, in January of this year, we actually deployed our Crimes of Violence data dashboard. Now, this data dashboard, it provides key characteristics for guidelines eligible crimes of violence sentenced in Maryland Circuit Courts in fiscal year 2022. So here's a screenshot of what it looks like. You can see there's various tabs that you can flick through. If this is something that may be of interest to you, please feel free to check it out. It is accessible via our website. Lastly, just want to note, recognizing the importance of studying racial disparities in the criminal justice system, the Commission in 2022 initiated a series of analyses to examine the components of the sentencing guidelines to assess whether racial differences are exacerbated at sentencing. And 2 years later, during the February 2022 review of the Commission's fiscal year 2023 budget, the Maryland Department of Legislative Services recommended that the Commission prepare a report addressing the extent to which Maryland sentences are influenced by racial bias. Accordingly, on July 17th of this year, the Commission released a report titled An Assessment of Racial Differences in Maryland Guidelines Eligible Sentencing Events. This report is a culmination of the Commission's analysis of race and sentencing, which began in 2020, and its response to the DLS recommendation. It provides a descriptive analysis of racial and ethnic differences in Maryland sentencing for guidelines eligible sentencing events in calendar years 2018 through 2020. If you subscribe to our listserv, you may have received notice about this report. But if this is something that may be of interest to you, please feel free to check it out on our website. So with that, I'm going to wrap up just by highlighting a few of our commission resources. Our main website here, the www.msccsp.org. It's continually updated throughout the year. It's a really useful resource for any individuals who implement the sentencing guidelines. The website includes the annual reports that I discussed earlier, which are a great source to learn more about the recent sentencing trends and the work of the commission itself. Also want to highlight our guidelines e-news, which helps to inform about changes to the guidelines. If you subscribe to our listserv, you receive them directly. If you don't subscribe but would like to, you can actually enter your contact information right on our main homepage, or you can send an email to a general email account and I'll be happy to add you to our listserv. But all of our guidelines e-news can also be accessed from our website. We also have sentencing snapshots. So more recently, we started producing a series of topical mini reports that we title sentencing snapshots. They are intended to provide a quick review of sentencing trends and other topics of interest. So here's a screenshot of our most recent issue from August of 2023. This provides a closer look at sentencing trends in Maryland circuit courts for child abuse. So we've gotten a lot of positive feedback in response to them. Again, if you subscribe to our listserv, you receive them directly, but they can also be accessed from our website. We also have PDFs of our guidelines manual and guidelines offense table, access to MAGS and the guidelines calculator tool. Various instructional and support materials can be accessed from our training page here. You can see we'll have our most recent webinar recordings. So again, if you have a new colleague who comes on board or if you need a refresher, you can access them then. We also have a YouTube channel. So if you go to YouTube and just simply type in MSCCSP, you'll see all of our training videos available there. Our crimes of violence data dashboard that I mentioned can be accessed from our website. If you ever have any questions, comments, feedback pertaining to the guidelines, you can feel free to reach out to us at 301-403-4165 or via email at msccsp@umd.edu. I'm usually the first point of contact, so if you've reached out to us, I'm sure we've spoken at some point, but again, we're always happy to help, so please feel free to reach out with any questions. With that, I just want to quickly check in with my colleagues to see if there's anything that needs to be addressed before we conclude. Stacy or Sarah, anything to be addressed?
Hi, Catherine. No, we don't have any outstanding questions.
Okay, great. Thanks, Stacy. Well, thank you all for taking the time to attend the webinar this afternoon. I know it was a lot of information, but I hope you all found it to be helpful and informative. And again, any questions you have, we're happy to help. So please feel free to reach out to us. And with that, everyone have a great rest of your afternoon and have a great weekend.
Thank you.
Thank you.